The entity that is responsible for these municipal hospitals is known as New York City Health and Hospitals Corporation, or the abbreviation HHC. That is the organization that's responsible for those municipal hospitals. And the time limit is extremely short, 90 days. And then you have only a year and 90 days within which to file a lawsuit from the date of the wrongdoing. Now, there are a number of procedural steps that occur after you file your notice of claim before you are permitted to file a lawsuit. And one of those steps involves a mini hearing that's known as a 50H hearing based upon the general obligations law, and it's like a mini deposition. And the purpose, its function, is so that the Health and Hospitals Corporation can investigate and determine what actually happened. Now, let me share this with you. Your notice of claim, in some regards, has to be as specific as possible. You have to identify what it is, first of all, where it occurred, where the problem occurred. You have to identify what you believe was done wrong, what injuries your client suffered as a result of that, and in some instances you may be required to list or itemize the damages. And if you fail to put that information in there, you may get kicked out later on because your claim was not sufficient enough. It was not detailed enough. But let's assume that you've done that. You would then have only 1 year and 90 days to file suit. Now, what happens if your client comes to you, let's say 120 days, 180 days, 5 months, 6 months down the road, after they suffered their injury? Can you still file a claim against Health and Hospitals Corporation? How many of you think they can? How many of you think they can't? Okay? The answer is there is a special procedure that we are allowed to go after to petition the court for the purposes of filing a late notice of claim. And in order to do that, there are procedural hurdles that we must overcome. So merely because the client comes to you and it's beyond those initial 90 days does not mean they can't bring a claim or a lawsuit. It simply means you as the attorney, or the attorney you're going to ultimately refer the case to, now has a significant hurdle and a significant challenge. And I'll give you an idea of what's involved. In order to bring a malpractice case in New York, we are not permitted by law to start a lawsuit unless we get confirmation by a medical expert that we have liability, that we have causation, and that we have damages. And that is an absolute rule. Okay? It's not like a car accident case or trip and fall or dog bite case where somebody comes to you and they say, Mr. Oginski, I was just involved in a car accident, I got hit in the rear. Great, tomorrow we're going to start your lawsuit. Can't happen like that in malpractice. In malpractice, we have to investigate. We have to get all the medical records. I have to go through every single page of every record. And then I have to get confirmation, send all those records out to a medical expert in order to confirm that there's a valid basis for a case. And then I have to certify to the court that I have done that step. Otherwise, we are not permitted to bring a lawsuit for med-mal here in the state of New York. So that's a key component. So now, if your client is at the municipal hospital, suffered injury, it's beyond the 90 days, now you have to go through the same exact process, and the time is ticking. It takes months to get all these records. It takes weeks and months to get an expert to review all these records. So again, your time is ticking. You're losing precious time. And you have to do this as expeditiously as possible. So what happens next? There are instances where the court will permit the client to file a late notice of claim, provided the medical records are still available and there's a good likelihood that the doctors who are involved in the care are still there. Okay? There are instances where the court will say no. You no longer have the ability to bring a notice of claim, a late notice of claim, and now you are prevented from going forward with the case. All right. So now let's jump ahead to something else. We talked about the statute, the time limit for a municipal hospital. What about in a wrongful death case? How many of you believe that in a wrongful death case against a private doctor or private hospital, you have more time than in a regular malpractice case? Show of hands. How many think you have less time? Okay. The answer is you have less time. You have only 2 years from the date of death within which to bring a lawsuit for wrongful death in New York against a private doctor and private hospital. So now let me make things even worse and throw another monkey wrench in. Your client is in municipal hospital. They went to Bellevue Hospital for surgery. They died the loved one died as a result of wrongdoing, and they come to you now, it's 2.5 years later. Can they bring a lawsuit? The answer is no. It's beyond the time limit for a municipal hospital. It's beyond the 1 year and 90 days. You do not get that benefit of 2 years in a municipal facility. So keep that in mind, because that will help you understand whether or not this particular matter may be timely.